record reflect we are back in session. Parties and counsel are present. All members of our jury and our alternates are present. And Mr. McStay is back on the witness stand to resume his testimony. And Mr. Owens, you may resume your examination of Mr. McStay.
Thank you. Good morning, Mr. McStay, at least for another 20 minutes.
Good morning.
How are you today?
I'm good.
Okay. You mentioned a term yesterday. I want to make sure everyone understood what it was. A DBA. What is that?
Fictitious business is a doing business as, so you gotta register that.
With who?
The county and origin of your business. So for me, I went to Lake Forest or Good Hills and filed mine before I sent mine off to the contractor's form.
And then back to the time that you went out on your own with your business and Joseph pursued his business pursuits. At that time on, did you have any intimate knowledge or even working knowledge of how he financially ran his business?
No.
Did you have access to any of the records?
No.
Did you have access to any of the bank accounts?
No, sir.
You weren't a co-signatory to any of the accounts or loans or anything?
No, sir.
So if someone were to ask you questions about certain bank accounts that existed in December, January, February 2009 into 2010, would you really have any knowledge of those?
No, sir.
Did you have any passwords or access information to his computers, his cell phones, his online accounts, anything like that?
No, sir.
So at some point, you mentioned that you talked to your brother approximately once a week, depending on how life was, right?
Correct.
When do you recall the last time talking to your brother before the events that bring us here today occurred?
I thought I talked to him, might have been the week before, because I think he played soccer that Friday, but I'm not sure. It might have been that week. I'm really not sure.
Do you recall telling detectives or investigators that the last time you recall talking to him on the phone was February 1st?
That's a possibility, but if my recollection would be better back then than today.
Sure, and I'm sure it is for all of us. Would looking at a copy of part of your police reports, the statements you made to the police, refresh your recollection?
Yes, sir.
May I approach? I'm
Sure.
sorry. You already gave us universal permission. I forgot.
Can we get a base reference?
2126. I'm going to direct your attention to that, looks like third full paragraph here. If you want to just review that.
Sure.
You don't, to yourself.
Yes, sir.
Does that refresh your recollection?
Yes, sir.
And sitting here today, now that you've read that and thought about it, does February 1st sound accurate as the last time you believe you had contact with your brother?
Yes, sir.
And would that have been in person or on phone?
That would have been on the phone.
Do you remember what day of the week that was? By any chance?
Probably a Monday, I'm
Well,
guessing.
let's look. I have exhibit 567 up here. Can you describe what that is?
That's a calendar.
Okay, and what dates does it cover?
The 24th through the 6th.
Okay, you see the first on there?
Yes, sir.
Okay. So I'm going to write on here in blue ink, Mike, last contact Joe. Is that accurate?
Yes, sir.
Okay. So we're going to come back to this a couple times probably. So I'll leave that there. Do you remember what you guys talked about?
No, sir.
So it was nothing of significance to lodge itself in your memory banks.
Correct.
at some point after that, were you alerted in some way that no one had heard from your brother in some time?
I was.
And can you tell us how you became aware of that?
Again, it's a little foggy, but I believe I was on the phone with my father on the 9th, which would be a Tuesday, I think. And he said he had just gotten an email from Dan Kavanaugh saying that Dan was concerned that he hasn't, Joe's not answering his emails, customers' phones, and that's not like him.
Overruled to be admitted to show what information he had as to what he did next, not necessarily for the truth of the matter asserted in the email from Kavanaugh to his father.
Thank you. You can finish if you with us more.
So I was on the phone with my father. He said he just got an email from Dan. My father said he got an email from Dan Kavanaugh saying that Joey was not answering his phone nor answering customers' emails, and he was concerned. I then contacted my mother on the cell phone. She said, and it's a little foggy, something to the effect that either Chase had just left her house or Chase was going down to the house or something to that effect. And at that point, I then asked her for Chase's phone number, or Charles Merritt's phone number. And then I contacted Chase directly.
Okay. Well, the first immediate question is, up to that point, I assume from your answer, and tell me if it's correct or not, you had no contact information for Charles Merritt.
I had not, no.
No phone number, no address, no email address.
No, sir.
And up to that point, what kind of contact had you had, if any, with a Charles Merritt?
I believe the first time I actually met him was February 13th, the day I went to the house.
Okay.
But
That would be in person.
that would be in person, yes, sir.
Prior to that, talking on the phone?
Yes, on that Tuesday, the 9th, I spoke to him and I said, hey, if I need to come down there right now, I'm on a job in Huntington Beach, I can leave right now. And he said to me that, no, don't worry about it. I'm going to be coming down here the next few days. I said, okay, fine. Then for sure I'm coming down on Saturday, 10 a.m.
Okay. So let's backtrack a little bit and fill in a few gaps and dot some I's and cross some T's. You said you met with Charles Merritt on the 13th, and that was the first time you had, believed, met him in person.
Correct.
Do you see that person in court today that you're referring to as Charles Merritt meeting on the 13th?
Yes, sir.
Can you please inform the court and the jury who you're referring to in this courtroom?
The defendant with the red tie and blue shirt and glasses.
May the record reflect the witnesses identified the defendant.
Record so reflect.
Then, so let's backtrack a little bit. You mentioned the 9th was the phone conversation with your father, right?
Yes, sir.
So on Exhibit 568, is that another calendar?
Yes, sir.
And what dates does it cover?
The 7th through the 20th of February, 2010.
And so you were alerted. Mike spoke with Dad. RE, meaning regarding Joe. Is that accurate?
Yes, sir.
Okay, and I abbreviated spoke with S/W.
Okay.
So does that reflect correctly what your answer is and what you know?
Yes, sir.
Okay. And that conversation that's alerting you to, hey, haven't heard from Joe in a while, was being relayed from Dan Kavanaugh to your dad to you.
Correct.
Okay. At least that's the information you have at this point.
Yes, sir.
Okay. Up to this point, have you personally spoken with Dan Kavanaugh at all on this issue?
I don't believe so.
Well, I guess in general, did you regularly talk to Dan Kavanaugh?
No, sir.
Do you even have a memory of the last time you had talked to him prior to these events occurring?
I'd see him from time to time, like at my brother's house, if I popped in, but that was really my only, it's more of an acquaintance.
And when you say your brother's house, that would have been either in Corona or in San Clemente,
Primarily in San Clemente.
because I believe you testified yesterday you had not been to the Fallbrook house.
That's correct.
Okay. So then, on the 9th, the gap from the 1st to the 9th, was that any reason for you to be concerned that you hadn't heard from Joe?
No, we were both pretty busy in our lives.
Well, I guess what I'm asking is, despite hindsight, what you know almost 10 years later, 9 years later, but at the time, would that have been something of to cause concern that, I haven't heard from Joe since the 1st?
Correct, it's not, it wouldn't have been that big a deal.
If it had hit your radar at all, what would have it, when you realized you hadn't heard from Joe since the 1st, what would it have caused you to do, if anything?
If I ever had a concern, I would just call him.
So at this point, up until the 9th, you have no reason to be concerned about Joe, do you?
No, sir.
You hadn't received any 911 calls from family members?
No, sir.
You hadn't been contacted by any law enforcement?
No, sir.
You hadn't been contacted by the defendant?
No, sir.
So 8 days have passed at this point before you, if anything, hear anything.
Correct.
Okay. So on the 9th, after talking to your dad and receiving that information that he received from Dan Kavanaugh, you called your mom.
Yes, sir.
You indicated in your testimony before we backtracked that your mom indicated to you that either the defendant was just there, was on his way there, or something. Can you clarify that for me?
Either he was going down from my mother's place in Trilogy, the Glen Ivy area, down to the house to look after the dogs, to move the water bowl, to crack it open to kind of see if someone was taking care of the dogs. I don't remember if he was just going down to do that or if he was just returning from that.
So at least your frame of mind and knowledge at that point is that your mom had been alerted by the defendant and that the defendant was going to or had gone to your brother's house.
That's correct.
Okay. So at that point, you have no reason to be concerned anymore, do you?
You mean after, on the 9th?
Yeah, when you hear that.
It brought some concern to me, but I felt like someone was, because I would have left my job and went there, but I felt like someone was looking after the house. I didn't know if he went on a little vacation because Valentine's was there, so I wasn't too alarmed, but I was concerned.
Well, at least at this point, you know that your mom's aware, the defendant's aware, and
Objection leading.
Sustained.
at this point, is it true that you know, your mindset is that your mom's aware and the defendant's aware?
And my father.
And your father.
Yes.
And isn't it true that your mindset at that point, if I understand your testimony, is that someone was actually taking a physical action to check?
That's correct.
Okay.
I
So
felt
what?
like I had eyes on the house.
Okay. Otherwise, you would have dropped everything and done it.
Absolutely. For my brother, sure.
Did you ever talk to, personally, Dan Kavanaugh on the 9th or shortly thereafter?
I don't recall.
Did you ever get an update from the defendant after his alleged trip to the house?
I don't remember.
So, at a minimum, it was your understanding he was going to or had, but you don't recall any actual verification that he did. You'd have no way to know that, would you?
Yeah, but I don't remember.
You weren't there?
No, sir.
Okay. The only way you would know that that actually had happened is if the defendant
Sustained.
would. The only way that you would know that he actually did it is if the defendant told you.
Correct, or, yeah, like we talked on the phone or something.
Well, that would be him telling you, right?
Yeah.
Okay. Tell us about your conversation. Did you talk to the defendant on the night?
Yes, sir.
And tell us what that conversation entailed.
I don't remember exactly, but it was something to the effect of, he was down there, he checked the water bowls, the dogs were outside, the shed door was open, he put a bag of food down or something, but he was going to be going down there throughout the week, he told me, so I didn't feel like I needed to rush down there.
So let me backtrack a little bit, or a little bigger picture issue. Did your brother and Summer have some connection with the Big Bear area?
That's correct. I believe at the time that her mother lived up there, and I thought they might have went up there to have a little R&R.
Did you have any contact information for Summer's mother?
I did not.
Okay. Did you attempt any, after the 9th of being alerted this, any attempt to call your brother on the cell phone or house phone?
I believe I did try.
Did you get any response?
No, sir.
What is, after the 9th, in the conversation with the defendant, what is the next thing in the series of events that you recall happening?
Before we get to that, it's about 12, so we'll go ahead and take our noon recess at this time until 1:30. Again, keep in mind the admonitions previously given to you, not to form or express any opinions about the case, not to discuss the case, and we'll see everyone back at 1:30. All the jurors have left. Counsel and parties are still present. Counsel wanted to address something.
Yeah, two brief matters, Your Honor. First, during the morning break, it was observed of the McStay family and Ms. Mitchley speaking about something in front of the jurors when they're walking through the halls. Can the court just remind the family members not to just have conversations in front of the jurors? The second is, when this trial started, Mr. Doherty and I had an agreement that we could do digital presentations of the exhibits. If that agreement is no longer in effect, then I need digital copies of what the people are entering into exhibits and they're projecting, or we have to come to some agreement, or I'll have to just submit extra digital copies of every exhibit for the court so we can use ours. And if they're still going to say whether or not those are the same, that I'm altering them, then that's going to be an issue because now they're questioning the defense's integrity and whether or not we would modify exhibits. So I just want to clarify understanding of what we're going to do from this point forward to not interfere with our effective cross or later presentation of evidence.
Well, I think that the issue with regard to the video is you were reading off information from what's on the file, but it wasn't on the screen when you were initially reading it off. And I didn't know what you were referring to, and it sounded like the prosecution didn't know what you were referring to.
It was the file name that's on the top of the viewing box that came from the file, the exact file that they put in.
If it's just a digital copy of what's up there and it's identical, then I don't think there's an issue. But if there's something on the digital copy that's not on the exhibit that's marked and being shown to the jury, then I don't know how you can be referring to something that's not part of the exhibit.
Right. Because just the objection was, I don't know if it's the same thing, and that led me to think that, I don't know if he's altered it or if it's the same thing we put.
I don't think there was an objection. I think it was just a matter of like, what are you referring to? Where is this information coming from?
I just want to have it clear, do we have the ability to use the same exhibits they entered just by having the digital copy provided by the government, or do we need to prepare our own, and is there going to be further objections to us doing a digital presentation of live exhibits?
Assuming they're virtually the same, I don't see a problem with that, with putting your digital copy up versus the actual exhibit.
I agree, I just want to know if the people are going to say that.
I think what Mr. McGee is saying is that's what we did, and we still got the objection, even though we cleared it beforehand in a pre-trial agreement. I think
Actually,
the
that's
issue.
the defense's misunderstanding, I think, of what that process was going to be. So for example, Ms. Rodriguez or even I has shown a physical exhibit, a photograph, to a witness. Then a digital copy of that is shown on the screen. The issue that was being taken with this particular thing, it wasn't like a photograph, it was a disc. And when I see the disc sitting behind us, I know that he's not showing the contents of the disc. And what was titled up there, it didn't seem to be a screen capture exactly of that disc, because it had digital copy exhibit 417, and it had other material to it that didn't show in the original exhibit. When we have projected a digital copy of a photograph, there isn't that extraneous information, and we know where it came from.
I can tell you where it came from. It came from the people's exhibit list that I got from the clerk, and that's what they titled it. So I just put the title of their exhibit and the title of the digital file.
I don't see an issue here.
I don't either. I just want to make sure that we're entitled to do this and we don't have numerous.
You're entitled, if there's a photograph that is marked as an exhibit, that's shown on the screen, and then you want to show the witness the same photograph, and you're using your digital copy of that photograph, there's not an issue with that. But if the digital copy that you have has additional information or additional scenes in it that are not part of the exhibit, then obviously you cannot do that unless you mark it separately and lay a foundation for it.
I agree with that.
All right. So there's no issue. As I say, the only issue that came up with regard to the video is we had the screenshot from the actual video, and you were reading off some identifying information about the times and the size of the file and so forth, and I didn't know what you were referring to. It wasn't on the screen, and it sounded like at that moment, the prosecution didn't know what you were referring to. So once it was clarified that it was on the disk where the files are identified, there wasn't a problem. And just a reminder to all audience members, again, not to have any discussions in the courtroom or in the hallways. Jurors may be present, witnesses may be present, media may be present, so you might be talking about something, someone overhears that, it could cause a problem. So again, remind you not to have those kinds of conversations in the courthouse area. And we'll see everyone back at 1:30.